Hey guys, this is John Watts. I'm a consumer protection lawyer. I want to welcome you to this video. I want us to look at this recent case of Ibarra versus Experian information. This is from Kansas, November 19, 2020. Really three take-home lessons I want us to understand. One is, what is a motion for judgment on pleading? So here we have a credit reporting agency sued under the FCRA, the Fair Credit Reporting Act, and they have filed what's called a judgment on the pleadings. And then I want us to really understand the difference between the two major types of claims against a consumer reporting agency. So there's what's known as an EB, maximum accuracy claim, and then an I claim, which is a reinvestigation claim. And then finally understand about willfulness, which basically means statutory damages, which can be $1,000 per violation, and punitive damages to punish and deter this credit reporting agency and the other credit reporting agencies from doing this type of nonsense. So let's take a look at this decision here. And this is from Judge Daniel Crabtree. And so we have Experian has filed a motion for judgment on the pleadings. And the judge just goes ahead and tells us, hey, I'm denying this motion. So here are the facts. And just to give you the real quick version, then we'll look at this. Somebody files bankruptcy, and after they file bankruptcy, they take out a couple of credit cards. But then when their bankruptcy is done, this is a Chapter 13 bankruptcy, Experian is reporting that those accounts were discharged in bankruptcy. But they weren't, because they were taken out after the bankruptcy. So it's a little different twist on the normal bankruptcy FCRA type of case. So let's look at it. So we file bankruptcy, and then we're issued 2 credit cards by the Bank of Missouri, and this is to start rebuilding credit. So again, this is a Chapter 13 where we're paying for usually 3 or 5 years of our debts. And then there was a discharge in 2018, and that did not include those 2 Bank of Missouri accounts because those were incurred after the bankruptcy was filed. But then Experian starts reporting that these credit cards were included in bankruptcy and discharged. And so what does the plaintiff do? The consumer has her bankruptcy attorney notify the defendants, hey guys, y'all are misreporting this. And Experian failed to correct the inaccuracies and re-verified that the reporting was accurate. And so the consumer disputes again, and same thing. And so the credit cards still show the discharge accounts as owing and able to be enforced and collected. So it doesn't make sense. I mean, if you're going to show that they're discharged, then you don't owe any money on it. So Experian is really messing this up here. So there's really one claim or one count, and that is a violation of the Fair Credit Reporting Act. But there's 2 different versions of it. There's what's known as the 1681 EB, and that's maximum accuracy, and section 1681I, which is a failure to use reasonable procedures when reinvestigating the claims. So let's figure out, first of all, what is the legal standard? Well, a motion for judgment on pleadings is really the same as a motion to dismiss. And this is a pretty common tactic, the motion to dismiss. Motion for judgment pleading is a little less common, but it's all the same thing. It's really just a matter of timing. Normally, as soon as you file your complaint, and instead of answering the complaint, the defendant files a motion to dismiss. A motion for judgment on pleadings tends to happen after the time period to amend or modify your complaint has expired. Then they file a motion for judgment on the pleadings. And so what we're looking at is, does the complaint, it's called a petition here because this was filed in state court, and in this particular state court, it's known as a petition instead of a complaint. So a judge calls it a petition, but just think of that as the complaint. So the complaint fails to state a claim to relief that is plausible on its face. Well, when does it have facial plausibility? When it allows the court to draw a reasonable inference that the defendant's liable. Okay? And so it demands more than just labels and conclusions or just reciting the elements. And you have to give the court reason to believe that this plaintiff, the one bringing the lawsuit, has a reasonable likelihood of mustering factual support for these claims. So it's this plaintiff and these claims. And so you assume that the allegations are true, but the court says, I'm not bound to accept as true legal conclusions. And threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice to state a claim. And then judge points out, the factual allegations don't have to be plausible because we assume those are true. It's just the relief that you're asking for has to be plausible from the facts alleged. So the court says, look, if I strip away the supposed facts that I don't have to believe, in other words, things that are just conclusions, then I will believe all your facts. And then you just have to show me that it's plausible. Doesn't mean it's likely, just plausible that you will win this case. And so then the court points out, must liberally construe the pleadings and make all reasonable inferences in favor of the non-moving party. Here, the non-moving party is the consumer, the plaintiff. And the court's function is not to weigh the potential evidence that they might present at trial, but to assess whether the complaint alone is legally sufficient to state a claim. And if it's not, then the case is dismissed. So let me talk a moment about this weighing of the evidence. A lot of times defendants, credit bureaus, furnishers that we sue under the Fair Credit Reporting Act will come in and say, well, look, the plaintiff says this, but we say this other thing, and ours is more believable. So, a jury would believe us rather than them. Well, that's not appropriate at the motion dismiss stage or judgment on the pleading stage. That's for trial. And to some extent for summary judgment after all the evidence has been compiled. But even then, at summary judgment, you're not supposed to weigh the evidence. Okay, so give you a car wreck example. I sue you for a car wreck. I say I had the green light. You say you had the green light. We both testified to it. The judge is not supposed to say, well, I believe John or I believe you. That's for the jury normally. Okay, so now let's get into the analysis. So why was the FCRA passed? To ensure fair and accurate credit reporting, promote efficiency in the banking system, protect privacy. So we've got these two claims. First is this claim under 1681 EB, and that is the defendant, Experian, failed to use reasonable procedures to assure maximum possible accuracy. And then number two is Experian failed to conduct a reasonable reinvestigation to determine whether the information it provided about the plaintiff that the plaintiff then disputed was inaccurate. So these are two distinct duties. So EB is whenever a credit reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual. Now this other section, Section 1681I, just remember, I is for investigation, says if the consumer disputes the completeness or accuracy of any item, then the credit bureau shall conduct a reasonable reinvestigation. It's called reinvestigation because we presume that they do an investigation initially. That's what this EB is. Hey, when you accept information, you better investigate to make sure it's accurate. But when the consumer says, hey, this is not accurate, now under Section I, we're conducting a reinvestigation to determine whether the disputed information is inaccurate and record the current status or delete it. Okay? And then the plaintiff says that you violated Section 1681N, which is willful, and Section 1681O, which is negligent. So the defendant makes three arguments. Number one says, well, you failed to state an inaccurate reporting claim. Why? Because they say, this is under Section EB, that maximum accuracy, say, well, we cannot incur liability about the bankruptcy because we don't have to go analyze complex legal documents. And then number two, the defendant says, well, you didn't state a reasonable reinvestigation claim under Section I because there's just no facts that you've alleged that we failed to do a proper investigation. I did a video on this maybe a couple of weeks ago, a month ago, about this is all negligence based. Okay, so this is very similar to a car wreck case. Okay, we all understand driving a car, we have to drive reasonably. Okay, and that means under the circumstances. So if it's a clear sunny day versus there's terrible fog and there's ice on the roads and my headlights are out and it's midnight, now that's a different standard. So Experian saying here, well, you didn't allege any facts that show that we did a lousy investigation. And then their final argument is we didn't do anything that constitutes willfulness that would allow for punitive damages. So the judge is going to take each one of these. So let's start off with this EB. So what are the elements? In other words, what do you have to prove? And at this stage, what do you have to plead to show a Section 1681 EB maximum accuracy claim? Well, in this circuit, it's 4 items. Other circuits will add a 5th item, which is publication. In other words, somebody needs to have pulled, besides the consumer, somebody needs to have pulled the credit report to see this so that it is publicized to them. All right, but here, that's not necessary. We just have these 4 elements. Number 1, failed to follow reasonable procedures to assure accuracy. Number 2, credit report was in fact inaccurate. Number 3, plaintiff suffered injury. And number 4, the failure caused the injury. Sometimes we call that proximate causation. In other words, defendant did something bad. Now, was that the proximate cause of the injury, or were there things in the middle, kind of between the negligent act and the injury? Okay. So in other words, if we're in a car wreck and then 6 years later I say, now my neck hurts, we go, well, that's probably, there's some things that happened in between you hitting my car and now my neck hurting 6 years later. All right. So let's look here. The only challenge that Experian makes is that first element. Remember, the first element is failed to follow reasonable procedures. They don't challenge that the credit report was inaccurate. They don't challenge that the plaintiff suffered injury, and they don't challenge proximate causation. Just this first element. And so the defendant says courts routinely hold that EB claims do not require a CRA is Consumer or Credit Reporting Agency, to engage in the type of legally complicated analysis. And then the defendant says you should find our procedures reasonable because there's no reason why we could not or should not rely on the furnisher to accurately report the status. Without some allegation, the furnisher is known to be unreliable or untrustworthy. Here's a little tip when you're doing dispute letters. Okay, an EB does not involve a dispute letter. At least it doesn't have to. But when you're doing a dispute letter, point out to the credit bureaus that this furnisher of information, this bank, this mortgage company, this debt collector is unreliable. Say to the credit bureau, hey, go look at the CFPB consumer complaint. Go look at the Better Business Bureau. Go look at the lawsuits out there. You'll find that whether it's Midland Funding or Capital One or NationStar, these are unreliable people. Okay? Do not trust what they say. Do your own investigation. It would be very unusual to not make that claim because the people that really have problems with their credit reporting, you're not the first person that's had this problem. Okay? Lots of people have problem with all these debt collectors, with these credit card companies, mortgage companies, etc. So anyway, going back to this. So the defendant's saying, well, we should be able to just totally rely on the furnisher. And then the defendant says FCRA does not require CRAs to engage in individualized, legally complicated review of bankruptcy dockets and similar legal proceedings to form its own conclusion. Sounds pretty complicated, right? And then they say it's not a strict liability statute. So an inaccuracy by itself is not enough. And that's true. That's different from the FDCPA, the Fair Debt Collection Practices Act that governs debt collectors. There, a violation of the law is enough. So if a debt collector is collecting something and it is inaccurate, then that's a violation of the FDCPA in almost all aspects of the FDCPA. All right, so how does the plaintiff respond? Well, they say, look, this whole reasonable component, that's a jury question. And I just have to plead an inaccuracy to survive this motion to dismiss or motion for judgment on pleadings. And then the plaintiff in her argument talks about, well, the defendant uses this pre-bankruptcy reporting and they could do post-bankruptcy reporting. In other words, they understand about bankruptcies. And this goes back to a decision about 12 years ago, a big settlement with the credit bureaus where they promised to kind of straighten up on their credit reporting. And that's the White versus Experian case. So the court then says, well, the EB claim generally is a fact-laden inquiry. Now, there are a lot of facts that you have to look at. And so fact-laden, fact-dependent, it's all the same thing. Now, that doesn't mean that you have to have a trial in every EB maximum accuracy claim. Okay, and they point out the Wright case in the 10th Circuit, and then there's some other circuits that say in the right circumstances you could grant summary judgment. Here's one. The EB reasonableness cannot be resolved on summary judgment unless the reasonableness or unreasonableness of the procedure is beyond question. And the Judge Posner, who's a famous judge from the 7th Circuit, said, the application of a legal standard to a given facts, notably negligence, which is the failure to exercise reasonable care, is treated as a factual question even when the underlying facts are undisputed. So, again, think about driving a car and whether you are negligent in driving a car. It's the same type of approach that we look at here. We're looking at whether you were reasonable in your conduct. So Experian, were you reasonable in your conduct? Well, we have to know what those facts are. And the Judge Posner here is saying, even if everybody agrees what the facts are, we still have to then make these evaluations about was this negligent or not. So we might all agree somebody's driving down the road at 70 miles an hour and they touch their brakes 100 feet before they smash into the car in front of them. We might all agree on that. Now the question is that still a fact question for the jury to say, was this reasonable or not? So 3rd Circuit, which is another court of appeals, says the reasonableness of credit reporting agencies' procedures is normally a question for trial unless it's beyond question. Okay, and then here's the 11th Circuit where I practice, which covers Alabama, Georgia, Florida. Determining the reasonableness of procedures will be a jury question in the overwhelming majority of cases. And the judge says, hey guys, mainly to the defendant here, we're not at the summary judgment stage. You, the defendant, Experian, are trying to throw this reasonableness out on the basis of the facts alleged. Okay? And judge says, nobody does that. Okay? So defendant, Experian, doesn't direct the court to a single case where court has granted judgment on the pleadings based on the reasonable procedures element. Okay? And they said this omission is telling but not decisive. And the court says, I still have to look at the pleadings. And the court says the pleadings are kind of meager. Okay, there's just not a whole lot of detail here. And we won't go through all this, but the point is the judge ultimately says this is enough. And there's also, I think it's in a footnote, the judge points out that, until you have the benefit of all the discovery, taking depositions and things like that, you really don't know, because we're talking about something that happens internally with Experian. So how would we know all the details of that? And so it says, given that the plaintiff's factual theory of reasonable procedure is difficult to identify how much more she could have alleged, and the plaintiff has given the court reason to believe that this plaintiff has a reasonable likelihood of mustering factual support for this element of her claim. And then the judge says, time will tell whether plaintiff can muster the factual support to survive summary judgment, but we're not at summary judgment. All right, now let's switch over to the I claim. Remember, that's the reasonable reinvestigation. After you tell the credit bureau there is an error. Defendant says plaintiff has identified nothing unreasonable about reinvestigation, but instead premises her claim solely on the continued existence of an inaccuracy, and that's not enough. And the defendant says, hey, look, we went to the furnisher, Bank of Missouri, and they told us it was fine, so that's all we have to do. And the plaintiff says, no, you just parroted this information. You didn't do an investigation. And so that's insufficient. So I may have told this story once before. I had sued, I think it was Equifax. I was talking to one of their sort of hotshot lawyers there. And he said, John, we are very insulted because you put in your lawsuit that we merely parroted the information from the furnisher. And I said, yeah, that's what you guys did. You just went to the furnisher and you repeated back what they said. He goes, John, that's very insulting. We went to the furnisher. We told them about your dispute. They investigated. They told us what to say. And then we said that back to you. And I thought he was like going to laugh, like, because that is parroting. And he didn't laugh. So I laughed. And I go, that's parroting, right? He never found that funny. I thought it was kind of funny, because he's like, John, all we did was go to them and we repeated it back. Well, when I was a kid, we'd go to somebody's house and they had a parrot. That's what parrots do. They just repeat back what they hear. And that's what these credit bureaus think that they can do. That's not the law. Okay, it's absolutely not the law. So plaintiff says you contacted Bank of Missouri, and then Bank of Missouri either failed to acknowledge the disputes or provided you with false information. And so at a minimum, Experian, you should have deleted the information it couldn't verify. And the court says, hey, I agree. Okay. And so let's look at some of this law down here. So requires CRAs to assure the accuracy. Okay. So that's EB. Remember, that's the first claim, the maximum accuracy, and the I claim. Okay. So they're similar there. To prevail on an I claim must prove essentially the same elements as an EB: unreasonable procedures, inaccuracy, injury, and causation, in addition to proving they informed the CRA about the inaccuracy. Now, reasonable reinvestigation is not defined, but the courts have consistently held a reasonable reinvestigation requires more than making only a cursory investigation. And this particular court, and I'll just highlight this here, says, look, you might lose an EB claim, but you might still win an I claim. Why is that? Because a credit reporting agency that's been notified of potentially inaccurate information is in a very different position than one that has no such notice. In other words, you've told Experian, hey guys, not just my whole report, but look at these 2 Bank of Missouri credit cards. These are wrong. Here's why they're wrong. Well, that's a whole different ballgame for the credit bureau. In short, when one goes from the EB investigation to the I reinvestigation, the likelihood that the cost-benefit analysis will shift in favor of the consumer increases markedly. So the question whether the reinvestigation is reasonable is generally one for a jury, except where the CRAs clearly employ reasonable procedures. So here's some more language. Once the credit bureau, like Experian, is affirmatively on notice that information received from a creditor may be suspect, it's unreasonable to simply verify the creditor's information through the automated consumer dispute verification. Sometimes it's known as the ACDV. And that's just where the credit bureau sends a little electronic code to the furnisher, usually with no human involvement, just verifies it. And see, the bureaus want to say, see, we're done, boys. Nothing more to see here. And the courts are like, no, guys. That is not enough. So credit reporting agency cannot rely on the fact that it's established some procedures, but it must prove those procedures are reasonable to address the specific dispute, not just disputes in general, the specific dispute. Look at this language. I want to highlight this. The grave responsibility imposed by Section 1681I must consist of something more than merely, parroting information received from other sources. Therefore, reinvestigation that merely shifts the burden back to the consumer and the credit grantor or the furnisher, that would be Bank of Missouri, cannot fulfill the obligation. So here's what the credit bureaus want to do. They say, hey, you told us this is false. We go to Capital One or Midland Funding. They tell us it's accurate. This is between you and them, boys. We don't have anything more to do with it. And the courts are saying, no. you've got to do more than just sit back and do nothing. You must actually do an investigation. So the obligation to conduct reasonable investigation may increase the cost and expense to a CRA, but it's necessary to discharge your congressionally mandated duties. So when a credit bureau says, hey, we want to report on you, that's fine. Okay, even though I don't have a choice on it, right? They didn't ask me if they can report. So they do that, but then they have the obligation, particularly when I dispute it, they must carefully investigate what I've disputed. And then going back to the quote, and in the majority of cases such as this, it passes to the trier of fact, the jury, to decide whether the credit bureau fulfilled its obligation. And so here's another one. The CRA refused to do anything further in response to the letter. The court determined the jury could find that they acted reasonably, but it could also reach the opposite conclusion. So that's like the green light. I say I had the green light. You say you had the green light. Well, a judge could say, I could believe John, but I could also believe you. So we'll let a jury decide it. And so then judge goes through some cases here. And, here's a claim by showing an inaccuracy and it remained. And the decisive inquiry, whether the Bureau could have uncovered the inaccuracy had it reasonably reinvestigated. So let me just give you a little practice pointer here when you're doing disputes. And we've talked about this in other videos. If you do some generic dispute, please investigate these 17 accounts and verify them. That puts almost no obligation on the Bureau. You've got to be very specific. What is the dispute about the Capital One or the Midland Funding or the Nation Star or the Bank of America or whatever it is? Okay, be specific. The more specific you are, and you point out errors to the credit bureau, now the greater the obligation is on the credit bureau to do the reinvestigation properly. So again, it's just like driving a car. If it's a flat interstate and it's sunny and there are no cars on the road and it's 2:00 in the afternoon and beautiful sunshine, well, your obligation is much different than if it's at night with fog, ice on the roads, your headlights are out, your brakes don't work, your steering wheel doesn't work. See, that's totally different. So the more specific you are to the credit bureaus, then it's sort of like we're adding the ice and the fog and the midnight and the headlights out. And you see where I'm going with that? You want to be as specific as possible. And so here's one way. You can be specific and say, the payment history, I need you to investigate that. Okay, well, that's better than just saying, look at everything on the account. But what's better is to say, I want you to investigate the payment history because you have me in July being 30 days late and in August being 90 days late. How can I go from 30 to 90? And then in this other year, you have me being current and then the next month being 60 days late. How did I go from current to 60? You see what I'm doing with that? You're being very, very specific with this. And so now that really raises the obligation of the credit bureau. Okay, so let's go back to the text here. So the decisive inquiry is whether the credit bureau could have uncovered the inaccuracy. Well, the more specific you are, then that makes it easier for them to uncover it. Okay? Because plaintiff has alleged he reported an inaccuracy, it remained. The court says those are plausible. All right. So now the defendant cites some cases and the court rejects those. And here the 10th Circuit in the Wright case analyzed the costs and burden if it employed the procedures proposed. Well, what were those procedures? Well, first, and this involved a tax type issue. They said the CRA should have hired a tax expert. And then the court said, but you didn't prove that would have made a difference. That's point number one. Point number two is the credit bureau could not contact the IRS to get this information because you never gave a release to the credit bureau. They just can't go get your IRS information. And then third, does not involve or require CRAs to determine legal validity of a debt, which is a question for the court to resolve. And the judge says, that's not what we're talking about here. So you could have discovered the 2 credit cards were not discharged because they weren't listed in the filings. It's pretty simple. The Bureau wants to say, oh, it's just so complicated. I mean, we have to have like a dozen experts in bankruptcy law. No, you could have just looked at the petition, bankruptcy petition. It's not on there. And you could find those records. You don't have to have our permission. It's public record. It's PACER. You can go down to the courthouse. It's pretty simple, guys. And then the defendant does not challenge the inaccuracy. Okay. So they don't dispute, this is inaccurate. And they don't say, well, you're asking us to determine the legal validity. No, I mean, it's a valid debt. They don't challenge that. And then we have this Davis case. This is actually from where I practice, Northern District of Alabama. And the court said, well, in that case, there were reasonable procedures. But the facts alleged here say Experian didn't look at other sources or delete the information. In other words, hey guys, did you go look at the bankruptcy court? Nope. Did you look at the bankruptcy petition? Nope. Did you contact? No. All you did is contact the furnisher and then you parroted back what they said. That's not good enough. Well, here's another case from Colorado 2017. Colorado court granted motion to dismiss after it determined plaintiff failed to plead an inaccuracy. Instead, they were trying to attack the debt. I don't remember this exactly, but I think this person lost in a collection lawsuit. And then they came into federal court and said, we want you to rule that debt's invalid. Well, no, it's already been decided. It's a valid debt. You lost. Now, look, here's a key point. When these debt buyers sue us and we win, we get a dismissal of prejudice. That's a court determining that debt is no good. Okay, at least in Alabama. Okay, in every state I've ever looked at, that's the law. So, going back to this Colorado case, court noted if a consumer had already litigated the validity in a judicial action, he may have a valid claim if the CRA, upon notice of adjudication, that continues to improperly report. So that's what we're talking about. Midland Funding sues me, I win, I get dismissal of prejudice, and they continue to report it. And I point that out to the to the credit bureau. Well, now they don't have much of an excuse. But again, going back to this case, the defendant doesn't contend plaintiff has pleaded no inaccurate. Remember, Experian goes, yeah, we admit it's inaccurate. It's false credit reporting. And so the court says, the defendant must show its reinvestigation consisted of more than relying on the initial source. So they lose that argument. Well, how about willfulness? Okay, the advantage of willfulness is you can get statutory damages up to $1,000 per violation of the Fair Credit Reporting Act, and you can get punitive damages. Punitive damages are to punish this defendant. Let's punish Experian, okay, because they did something bad. And let's discourage Experian and all other credit bureaus, discourage and deter them from ever doing this again. We want the bureaus, when they're thinking, should we continue to have these really lousy procedures and just willfully violate the law? We want somebody in that meeting to raise their hand and say, guys, do you remember that punitive damage award that happened in Alabama or in Kansas or in California? And they go, oh, yeah, we remember that. Say, we don't want that. Let's clean up our act because it's cheaper to actually follow the law than to get popped with punitive damage. That's the whole point of punitive damage. But first we have to see, did the defendant willfully violate the FCRA? So the defendant says, no way we've willfully violated. We just reported the data we received from Bank of Missouri, and that's enough. And the plaintiff says willfulness is one that you cannot resolve at this stage. And remember, the defendant's merely, parroting information. That creates a substantial risk to consumers because the bureaus are just repeating back what the furnishers are saying. Well, remember, the consumer has told you this furnisher is wrong. They're reporting false information. And if the bureau say, yeah, we don't care, we're just going to report back what this allegedly false furnisher is saying, that creates this terrible risk to consumers. So the FCRA does not define it. It just says any person who willfully fails to comply with any requirement imposed under this subchapter with respect to any consumer is liable for additional damages. Now, in Kansas, the Court of Appeals, I think that's 10th Circuit, says willful violation is either an intentional violation or a violation committed by an agency in reckless disregard. So recklessness is measured by an objective standard, action entailing an unjustifiably high risk of harm that is either known or so obvious that it should be known. So here's another one. So if the action is not only a violation under reasonable reading, but shows the company ran a risk of violating law substantially greater than the risk associated with reading that was merely careless. So again, it all goes back to always use car wrecks, because first of all, I've been doing car wrecks for 25 years, but also because we all drive a car or we ride in a car. And so is the risk of me being negligent by, let's say, driving 50 miles an hour in a 45 mile an hour. Okay, that's negligent, right? I'm speeding. Is that the same risk as me going 90 miles an hour in a 45 mile an hour? We would all go, no. I mean, the faster you go, the greater the risk, the greater the harm, okay? The greater the exposure to everybody else on the road is, okay? So that same thing here with the FCRA. We go, well, the way that they interpreted the law, which was wrong, is that the same degree of risk or is that a lot worse? Let's see what the court says here, because we're going to continue to look here at a little bit of this law and then the judge will analyze it. So here's a case, the Burns versus TransUnion. As a consumer, plaintiff is unable to plead furnisher specific errors during their internal investigation without discovery. Okay, so this is talking about at the pleading stage. Excuse me. At the pleading stage, we just don't know everything that they did, right? So we can't plead everything. So District of South Carolina reason requiring plaintiffs to plead specific instances or errors create too high of a burden because you don't have that information. And then the court says, well, that's true, but you still have an obligation to plead your case properly. So defendant's willfulness must be adequately pled. Assertions that defendant was aware of the FCRA but failed to comply with the requirements are sufficient to support an allegation of willfulness. Here's another one. Complaint alleges defendants recognized their statutory duty but intentionally ignored that duty and refused to take steps to comply with the regulations. And since they frequently involve facts beyond the pleadings, issues of willfulness often cannot be resolved at the motion to dismiss stage. Let me take a drink of water here. Okay, so now we're going to analyze it. We'll look at this EB claim, that's the maximum accuracy, and then we'll look at the I claim, which is the reasonable reinvestigation. Defendant says, hey, we can't have violated it willfully. We just reported what Bank of America told us. And the plaintiff says, no, this is a willful disregard. And because you have procedures, you understand about bankruptcy, you then should have procedures here to make sure what happened didn't happen. And the court says, I can infer the inaccurate reporting resulted from willful or reckless. And those are the same thing, willful and recklessness, the equivalent of each other. Disregard the FCRA's requirements. And the court may infer from the allegations that defendant relied upon procedures that knew or should have known presented undue risk, and they didn't fix it. All right, so now let's go down to the I. This is willfulness for the reinvestigation. And the defendant, you'll see their arguments are very similar. They say, well, we cannot have willfully violated the FCRA because it's not required to engage in individualized, legally complicated reviews. That sound familiar? So they're just making the same argument. And the plaintiff says, look, my bankruptcy lawyer told you, and you just ignored it. And you should have deleted it. If you weren't going to make it accurate, then you should delete it, which is true. And then the plaintiff says, you engaged in practice of parroting its information. That leads to an unjustifiably high risk of harm, which again is true. And the defendant just keeps saying, we can't be willfully liable. And let's look here. This is a famous case, the Cushman case. Once a claimed inaccuracy is pinpointed, so remember what I said about being very, very specific. Once a claimed inaccuracy is pinpointed, consumer reporting agency conducting further investigation incurs only the cost of reinvestigating that one piece. Okay, so this is compared to an EB claim where they have to look at everything on your report without any notice from you. But once you pinpoint, now look, you can dispute 17 items, okay? It's still the same analysis. They just have to investigate each piece of information that you have pinpointed. You've been specific about what is wrong. So the case law is clear. Reporting agency does not act responsibly by deferring entirely to another source of information, like the furnisher. The grave responsibility must consist of something more than merely parroting information received from other sources. So once the consumer disputes a reporting, the credit bureau must look beyond the information from the creditor to meet its duties. So it must mean more than simply making a cursory investigation. And then a reasonable jury could find that a knowing violation of the FCRA was a result of defendants parroting information. So the judge says, you've sufficiently pled the I claim because you said you notified the defendant of the inaccuracy. Defendant continued to inaccurately report, and that's sufficient. So bottom line is all the claims move forward. So let's go back to the top here. And so I want us to understand a motion for judgment pleading is basically the same thing as a motion to dismiss under Rule 12b-6. And then it's really important to understand the differences between an EB claim, maximum possible accuracy, and an I claim, which is a reasonable investigation, or more technically called reasonable reinvestigation, because they're supposed to investigate the first time under EB. But the I claim is the investigation claim. And then understand, what is this willfulness and how do we plead that so we don't get thrown out before we get summary judgment. Now, at summary judgment, we've got to have some solid evidence, okay, of all of our claims, including willfulness. We've got to have enough evidence that the judge says, well, you know, I could rule in favor of the credit bureau, but I could also rule in favor of you, so I'll let a jury decide this. And then it goes to the jury. So I hope that this was helpful to you, that you enjoyed it. Let me know if you have any questions or comments. And if you know somebody that you think would be interested, I realize this is a long video. I have short videos also. But, you know, these case decisions, to make them worthwhile, they have to, in my opinion, be pretty long videos to go through this. And if you think you have somebody that would like this, feel free to share it and, let them take a look at it. And as always, let me know if you have questions, comments, suggestions for other videos, and we will try to answer all those. And if you're not subscribed, feel free to subscribe. We do a new video every day on consumer issues. Okay, you guys have a good one, and I'll catch you tomorrow. Bye-bye.